The member for Rarieda.
Thank you, Madam Speaker. Madam Speaker, I want to clearly support the point of order by the minority leader. And I really want us to address this as a house, not as a partisan house, because these matters have consequences in terms of precedence. First of all, Madam Speaker, Standing Order 89 is clear as read by Honorable Andai, and 89.2 restricts discussion of active civil matters. It goes further in C to say that civil proceedings shall be deemed to be active when arrangements for hearings such as setting down a case for trial have been made until the proceedings are ended by judgment or discontinuance. Until they are ended by judgment or discontinuance. It is clear, Madam Speaker, that the case quoted, E389 of 23, is active, has been set down, it has not been ended by discontinuance or judgment. So it falls exactly on all fours under Standing Order 89. Madam Speaker, all the sections of all the articles of the Constitution quoted are true. But despite those provisions, in our wisdom as a house, we established the standing orders and included Standing Order 89. If it were to be possible, that there are certain matters that we are willing to discuss despite them being sub-judice, nothing would have been easier than to state it on the face of the standing orders. Madam Speaker, it is not true that the orders read only stop deployment of the police. To the extent that any court order stops deployment, it stops all the processes that lead to that. And one of those processes is bringing that motion in the National Assembly, and the National Assembly either passing or rejecting it. It means automatically that all these processes must be held in abeyance. Is it true, as Honorable Soro says, that we are not party to the proceedings? Yes, we may or we may not be. But whenever we learn of any matter that concerns us, and we want to nip it in the bud or fast track it, we usually join the proceedings. So not being part of the proceedings is neither here nor there. Court orders such as this bind everyone, whether you are part of the proceedings or not. And Honorable Soro knows that because he's a lawyer. Madam Speaker, the principle that sometimes it can be convenient to follow court orders and sometimes it can be inconvenient to follow court orders is one that makes us a laughing stock. Madam Speaker, only recently, the leader of minority sought to replace the deputy chief whip of the Azimio party. Someone else other than the concerned member went to court, and like in this case, we were not party. But when the court stops the process, the speaker held that in abeyance for months until finally that matter was disposed of. How is that matter different from this? How do students, how do Kenyans looking at us try to understand Parliament when we apply differential standards? We become a laughingstock. I think, Madam Speaker, it is unfortunate that sometimes we can conveniently think that we can ignore court orders and sometimes we cannot. In fact, in E389, which has been tabled before you, Madam Speaker, the Speaker of the National Assembly is a party. Whether the Speaker has chosen to appear or not is a different matter. And it does not make the orders not see. Lastly, Madam Speaker, the leader of majority says that we can only see what has been brought before us. You know, leader of majority, one day, when you become a lawyer, as I'm sure you will, or you will learn that only justice is blind. Justice is said to be blind. But any determinative authority must always take notice of what's happening aside. In the judiciary, we say judicial notice. Even this Parliament, if today we are sitting here and we learn even on your SMS, that something has happened, which is a national crisis, we will take parliamentary notice of it. You cannot say that you cannot take parliamentary notice of what's in public notoriety, and we know it. Madam Speaker, I think that to avoid this selective amnesia by my brothers and to maintain the dignity of this House, this debate should be held in abeyance, and if the Parliament wants to be a party, it should apply to be a party. Once it's determined, then we can come back to debate it. I so submit, Madam Speaker. Thank you.
What's your point of order? Because we need to bring this to a close, I'll pronounce myself on it.
Honorable Speaker, you know, Senior Counsel Otiende Amollo referred to me and said that when I become a liar, and I have no intention ever of becoming a liar. I have no such intentions of ever becoming a liar. I don't know if he said a lawyer or a liar, because, you know, from where Honorable Otiende comes from, you can never distinguish when someone is talking about lawyers and liars. And there's a famous movie, Honorable Speaker, called Liar Liar, that was about lawyers. So I have no intention, Honorable Speaker, for the record, to become a liar, nor do I intend to become a lawyer. But, Honorable Speaker, I think I have taken judicial and parliamentary notice of the court orders, Honorable Speaker. But the point I had made was that, one, there is no injunctive order against Parliament. The injunctive order is on those who are charged with the responsibility of deployment. And the court order dated 24th October or 23rd October is quite clear that those who deploy are the ones who are debarred from deployment. Parliament, Honorable Speaker, does not and has no capacity to deploy anybody other than deploying the Honorable Otiende Amollo on a trip to Rarieda, or deploy him on a trip to Mombasa or a trip to Turkey for other things, Honorable Speaker.